$50 and test at a private clinic.
Could have done that before.
Yes, absolutely.
That's my point. I can't get him in because of time.
Well, you said by 4:30. Oh, sorry.
Find out if they can test him right now. If you come back dirty,
I won't.
I am putting you...
Right out of the gate, notice the urgency here. When a judge says, if you come back dirty, I'm putting you in, that's not a threat, that's a legal fork in the road. This hearing instantly turns from procedural to high-stakes freedom versus custody.
PCC, we're requesting an adjournment of that, but as the court is reviewing, we have a bond violation issue.
Yes.
May I address the bond violation?
Yes, please.
Your Honor, I was not the lawyer on the record at the time that the arraignment was happening, so I wasn't there, didn't know about it. I did review it this morning. The bond document in the file does not order my client to be subjected to testing. It tells him don't do drugs. Now, I don't plan to use that.
Well, but counsel, go ahead. You can.
I don't plan to use that as my
one, but he's. Go ahead.
Not a problem. Judge, the problem is really the past and going forward. He tested positive for a drug which is a opioid inhibitor. That, of course, is a drug you cannot get and you cannot take if you are taking opioids because the combination of the two is likely to kill you. He has a prescription for that.
This part gets technical fast, so let's slow it down. Buprenorphine, often known as Suboxone, is legal only with a valid prescription and it actually blocks opioids. The defense is trying to show medical compliance, not drug abuse. Question is, does the paperwork back that up in time?
So, Judge, I have that available to the court.
He's on Suboxone.
He is.
Okay. But you're saying he didn't know that he had the test?
No. That is not my argument. But Judge, going forward, I believe there's a problem. He has missed the last two tests. The only reason he missed the last two tests is he is employed full time at Ford Motor Company. He has his employee badge in his pocket. If you can pull that out, we will offer that to the court. He works a crazy schedule. He builds cars, and he starts at 6 a.m. and he gets out at 5 o'clock at night. His testing facility closes at 4 o'clock at night. He's been there 5 years, but he doesn't have the sort of seniority to grant flexibility. So we apologize for missing it. So this morning, when I had no idea that there would be a bond
violation. What was the other drug, the amphetamine?
That was the initial time, Judge, and he's absolutely guilty of that. That was the first time he was ordered to test. Yes. Since then, he has not taken any of that stuff, and he will test negative today.
Well, there are two things. One, he had THC in his system.
Yes.
Whether he took it or not, he doesn't get a card till the next issued the next day.
Yes.
He also has abnormal creatinine, which is a problem because that usually will appear in rare circumstances, but typically when somebody's trying to mask.
So Judge, if I may, he absolutely flunked your first test, no question about it. But that was the first test, and since then, he has been clean. He missed the two tests.
I don't know how you say that.
This is a subtle but critical moment. Abnormal creatinine doesn't mean drugs, it suggests possible tampering. In court, that implication alone is dangerous. Even the appearance of masking a test can collapse a defendant's credibility.
I work in Wayne. It's a 2-hour drive. I drive literally 4 hours a day back and forth to go to work and get back home. I work till 5 o'clock. I called my probation officer. I want to test. It's not that I'm trying to get away from testing. It's impossible when it's at a time I can't get there. And I don't want to lose my job because that's some benefits for the kids. I mean, it's a rock in a hard place situation. And I'm just trying to figure out the best way to move forward without losing.
Did you talk to your attorney about testing?
Here's the human side colliding with the legal system. 4 hours of commuting, assembly line work, kids depending on benefits. Judges hear these stories every day, but here's the brutal truth. Responsibility doesn't pause just because life is hard. Should the system bend or stay rigid?
$10 for a test. At the moment, your court's charging him 12. And I mean, that is...
I don't mind paying the money.
It's
The facility closed at 4. I just get off at 5. I have no issue testing, Your Honor. I really don't.
Well, when I look at this, you sit up here telling me you don't have an issue testing. I've got 2 missed tests.
Correct. I have an issue because of the time, Your Honor. That's it. I'm hands down. It's just because of the time. And I'm not trying to skate. I want to. It's hard. It really is hard to get out of my job. It's an assembly line, so they can.
I understand how.
I want to fix this. I do.
Well, and I don't know why somebody's not contacting the court or somebody prior to us getting to this point today. And when you know you haven't tested.
Sorry, Judge. I read the email this morning. I had no idea there was a problem.
And it would be one thing if all that was showing up in the system is Suboxone, but that's not everything that's showing up in the system from the initial test. I really don't have much for August.
I'm sorry, I didn't.
I don't have testing for August. I mean,
yes,
effectively, I don't have it. The whole month. He doesn't test.
I want to, Your Honor. I do. I just need a facility that's a little later. I'm just scared to lose my job. It's really, I got my kids. I mean, it's just hard.
Judge, had I known, I would have made efforts to try to resolve this before today. I had no idea this was coming.
I just need a little help.
Any response from the people?
Your Honor, I'm trying to sort it out. My concern stems from the fact that this date was July 2nd of 2024, where the defendant was arrested in possession of 56 pills of Adderall, which will show up in his system as amphetamine. And when he was arraigned just this past month, he's given the opportunity to test to show that he was clean, and it shows that a year later he had that amphetamine in his system. Granted, it was right after he...
This is where the prosecution quietly tightens the noose. A prior arrest, pills, amphetamine still showing up a year later. Without consistent testing, the court isn't guessing it's protecting the public, especially when driving is involved. And here's the resolution: not mercy, but structure. Bond stays, rules get clearer, flexibility finally appears after accountability. Miss another test? No debate, no argument, straight custody. So let me ask you, did the court find balance here, or did it wait too long to draw the line?
The point is, he could have done that before. Yes. There is nothing that prohibits him from doing that. What I have and what the prosecutors added is that the only test I have is that same drug that's showing up a year past is still showing up in his system. And then I don't have any testing. Simple as that.
You don't.
If it's all one, I really did. My probation officer, well, she'll tell you. All right, sorry.
Court test him today.
I can't get him in because of time.
Well, we said by 4:30. Oh, sorry. Sorry, Your Honor, I'm sorry.
And find out if they can test him right now. If you come back dirty,
I won't.
I am putting you.
I have not taken none, I swear.
You know what? You need to be quiet about now. Can you see if they can get him tested?
Yeah.
He will test positive for the opioid blocker. Prescription, he takes it.
I understand that. Counselor, you probably should stop talking too.
I'm not good at that skill, Your Honor.
I know. No answer yet. You need to go over there and see if you can test. If you don't get tested, you're going to go.
So, Your Honor, may he take a sick day and test tomorrow morning first thing?
No.
Okay. Thank you, Judge.
I gave you your options. Go over there and test. If they let you in, fine. If not, you still got to come back here.
Yes,
and if you don't test, you're going.
Thank you, Judge.
Bye. Really? No, I'm kidding. You're welcome. He calls the case the people versus Randall Jolly.
Great. Maybe for the people in your house.
Your Honor, Mark Ellis representing Randall Jolly. Mr. Jolly, tell the judge your name.
Randall Jolly.
First thing that I'll do is I will adjourn the probable cause conference to the 18th, 2025, 9 o'clock. His test came back. He's positive for the marijuana. He did get a medical marijuana card the day after he first tested positive for marijuana. I'm going to suggest that you probably start or cease using that. But I have negatives on everything else. So what I will do is I'll continue his bond at this point with the admonition that if you miss another test, I'm not hearing argument. You're going. Simple. And then the other portion of that is that I will allow defendant may test. What county is that? If you live in?
Allegan. Allegan.
I'm a Michigan resident.
I'm sorry.
He may test in Allegan County at an approved facility by the Community Corrections.
Apologize, Your Honor, may I have the PCC date one more time?
Is the 18th.
Your Honor,
His test results, he must sign a release so that his test results are sent to Community Corrections.
Your Honor, if I may, first of all, thank you. I appreciate it. My condolences on this docket of yours today. Judge, in the interim, my client contacted his boss at work. It is possible that he can test at the Ford Motor Company. Evidently, they have those facilities in some way. If that can be arranged, that's good enough.
That if as long as Community Corrections will approve the testing and the manner of testing, I'm not so concerned. But those results must be released to Community Corrections so that they can be reported to the court. So he'll have to execute the necessary releases.
I'd be happy to do that. Do we have any idea who I would contact at Community Corrections?
I do not. So what I suggest is you call over there, indicate his name,